Have you ever used turmeric on a cut or a scrape? It's a home remedy that's been around for generations in a ton of cultures. But just imagine for a second, someone trying to patent that knowledge, to actually own the idea of using turmeric to heal. It sounds pretty strange, doesn't it? Well, that's exactly what happened, and wow, did it spark a global debate. Today, we're going to break down this whole incredible story and really get into this fascinating clash between ancient wisdom and modern law. So, yeah, this is the big question, right? On one hand, you've got intellectual property law, or IP law. Just think of it as the system that's built to protect new stuff. A brand new app, a new machine, some kind of breakthrough drug. It gives the inventor exclusive rights for a while. But on the other hand, you've got traditional knowledge. And this is the wisdom that's been developed and shared freely inside communities for, well, centuries. That turmeric remedy? Perfect example. So what happens when these two worlds collide head-on? We're about to find out by digging into some major legal showdown. All right, our first big case study kicks off with turmeric. And let me tell you, this case became a huge moment for India because it brought a pretty big problem to light, a concept that's now known as biopiracy. So what exactly is biopiracy? Well, it's basically when companies or researchers take biological resources or traditional knowledge from communities or countries, usually without asking or paying them fairly, and then they try to patent it like it's their own brand new invention. This case really started a worldwide fight to protect cultural heritage. Let's walk through what happened here. So in 1994, the U.S. Patent and Trademark Office grants a patent for using turmeric to heal wounds. This was a complete shock in India, where, this is just common knowledge. So India's Council of Scientific and Industrial Research, or CSIR, they stepped in and challenged it. And the evidence they brought was just so powerful. They provided proof of what's called prior art. They dug up ancient Sanskrit texts and other documents that described this exact use of turmeric hundreds of years ago. This proved the so-called invention was not new at all, and because of that, the patent was revoked. The Patent Office's official reason? It was obvious and not novel. Now, in patent law, novel means it has to be new, and not obvious means it can't be something that anyone in the field would just figure out easily. This was a massive, massive victory. And this case set a super important legal precedent. For any invention to get a patent, it has to be novel. The turmeric case proved that ancient documented wisdom counts as prior art. It's evidence that this knowledge was already out there in the public, and if there's prior art, then an invention isn't novel. The takeaway here is really simple. You just cannot patent something that's already known. The turmeric case was a real game changer, but it wasn't a one-off thing. Oh no, this was really just the beginning of a pattern. Let's look at two more huge challenges that came up right after, this time involving the super versatile neem tree and, of course, the world-famous basmati rice. Okay, so here we have two more of these critical battles. In the neem case, a European patent was given for a fungicide made from neem oil. Again, another piece of ancient Indian knowledge. After a long legal fight, that patent was also revoked. And the legal reason this time? It lacked inventive steps. That's another key idea in patent law. It just means the invention wasn't some non-obvious leap forward from what was already known. And then you have the Basmati case. A U.S. company, Rice Tech, got a patent on rice lines that came from traditional Indian basmati. This was a direct threat to India's farmers and its whole agricultural history. India fought back, calling it biopiracy, and eventually, the U.S. Patent Office had to throw out most of the company's biggest claims. So these wins were absolutely huge, but they were all reactive, They were fighting fires after they'd already started, and it really showed that India's traditional knowledge was super vulnerable on the world stage. So this brings up a really important question. How did India go from just fighting these individual battles to building a whole system to protect its intellectual property for the future? Well, the answer was to stop being reactive and start being proactive. India realized it had to build a really strong system at home to defend its heritage. So it set up a bunch of key organizations. You can think of them as the official guardians of India's intellectual property. And each one has a very specific, very important job to do. So first up, you've got the CGPDTM. That's the Controller General of Patents, Designs, and Trademarks. This is the main office, the central hub for everything IP in India. It handles patents, designs, trademarks, and also a category that's super important to our story, geographical indications, or GIs. So what's a GI? It's basically a label on products that come from a specific place and have certain qualities because of that place. Think champagne from France, or for India, Darjeeling tea. The CGPTM is the main regulator for all of it.
Next, there's CPOM, the Cell for IPR Promotion and Management. So if the CJPTM is the regulator, you can think of CPOM as the engine that makes things happen. Its job is to take the country's big national IPR policy, the grand strategy, and actually put it into action on the ground. It works to spread awareness, get different agencies on the same page, and just speed the whole process up. It's really the bridge between the policy and the practice.
And this whole framework also has bodies that are all about connecting IP with real innovation. Two of the big ones are TFAC and the NRDC. TFAC, it stands for Technology, Information, Forecasting, and Assessment Council. It basically acts as the country's tech think tank. It's always looking ahead, trying to spot future tech trends, and helps point innovation in the right direction. Then you've got the NRDC, the National Research Development Corporation. Its crucial job is to be that bridge, taking these brilliant inventions from public research labs and universities and helping to get them into the market. It helps turn academic research into real-world products people can actually use.
But, a system isn't just about organizations. It's also about giving people proactive support. So let's check out the specific programs the Indian government has put in place to actively encourage and help new innovators and startups protect their brilliant ideas.
The really foundational piece for this whole modern approach is the National IPR Policy, which was adopted in 2016. Now, this wasn't just some dusty document. It was a complete roadmap. The whole goal was to weave all the different pieces together: patents, trademarks, GIs, enforcement, awareness, into one strong, solid ecosystem. The vision was to completely transform India's IP landscape to create a place where innovation and creativity could just flourish.
So a key program that came out of this policy is SIP, the Scheme for Facilitating Startups' Intellectual Property Protection. Let's break down how it works. First, it's about fostering innovation by creating a supportive space for new tech to grow. Second, it facilitates protection. And this is the real practical help. SIP gives startups access to a whole panel of experts, lawyers and agents, to help them file for patents, trademarks, and designs, and often for a much lower cost. It just removes that barrier of complexity and money. And third, it promotes awareness. SIP runs workshops and programs to teach entrepreneurs about how valuable their intellectual property is and why protecting their ideas right from day one is so critical for their growth. So let's do a quick recap of this whole journey. We started with the challenge, these big cases like turmeric, neem, and basmati that showed just how vulnerable traditional knowledge really was. In response, India built its guardians, this strong framework of organizations like the CGPTM and CIPAM to manage its IP loss. And finally, this all grew into proactive support, creating policies and schemes like SIP to not just defend old knowledge, but to actively encourage and protect new innovation.
And this brings us to one last big question to think about. India has built this incredible system to both defend its past and fuel its future. It's protecting the knowledge of its ancestors and the inventions of tomorrow's startups, all at the same time. So as we look ahead, what other kinds of traditional knowledge, whether it's from India or anywhere else in the world, do you think deserves this kind of protection? And that is where we'll wrap up this explainer. Thank you so much for joining me to dive into this really fascinating topic. Hey, if you found this breakdown of India's patent battles helpful, do me a favor and hit that like button, and definitely subscribe for more deep dives into these kinds of complex topics. And I would seriously love to hear your thoughts on our final question. What other traditional knowledge needs protection? Let us all know what you think down in the comments below.